Good morning, Your Honors.
I'm pleased to hear from you.
Thank you. May it please the Court, my name is Elizabeth Haynes. I'm an attorney with the Federal Public Defender's Office. I represent Javad Fisher together with Caroline Platt on brief. Your Honors, this court in United States v. Carter was clear. It told district courts you must place on the record your particularized reasons for sentencing a defendant as you did. And in this case, the guideline range of 6 to 12 months, the district court more than doubled, sentencing Mr. Fisher to 30 months and providing no reasoning. The only reasoning he stated was, I think we've done all we can for Mr. Fisher.
But isn't it clear why he did it? He gave him repeated chances and the guy wouldn't, and your client wouldn't follow the rules and kept violating. Isn't that clear?
It's not clear, Your Honor, and it's not what's required by statute. It's not what's required by this court in Carter and what was required in Thompson.
You think that you don't think we can figure out why the judge did it? Now, you may say that he didn't state it on the record as is required, but you don't think from this record we know why he did it? Didn't he tell him why he did it? Or
he did not, but more importantly, this court has said we can't assume what the district court did. We should not take...
Didn't the district court say to him, if you come back, I'm going to put you in jail for a long time?
He did make that statement, but that was in the first revocation hearing. And this court should look only at the hearing...
You mean we can't go back and look at the course of events in this thing?
Your Honor, the best rule would be that the court should contain itself to the hearing at issue for several reasons. One is that
that's not what he asked you. He didn't ask you what the best rule is. He asked you, are you asserting that we can't go back and look at prior hearings? That's what he asked you.
I could not find any law of this court saying you should only contain yourself to one hearing or you should go back. But if this court sets a rule allowing parties to go back into the record and to look for reasons in other hearings, when does that stop? You can imagine a case in which a party comes to the court and says, well, he didn't provide any reasons on the record for the supervised release violation sentence, but look at the record at sentencing, and he provided sufficient reasoning there.
If it was clear there, why shouldn't we look at it? We should send it back so the court would say, the district court would say, well, I said this already in this case, but I'm going to say it again. And let me read from page 1812 of the transcript. Here's why I did it. If it's clear, now you can argue that it's not clear, but if it's clear, if we can glean from the proceedings, even the earlier proceedings, while the court did that, why wouldn't we look at it?
The court in this case...
No, I'm just asking that, why, as a general principle, why wouldn't we look at it if it's clear? Now, I'm going to let you argue that maybe it's not clear in this case, but why would we ignore that?
I think it's not clear. But
Right,
secondly,
that's not the question.
But the reason that you shouldn't is, first, the district court made no mention. He didn't have to go back and read the transcript. All he had to say was, I told you before. Three, 4 words, one sentence.
No, but you're answering from the facts of this case. I'm talking about the general principle of whether or not. You just said we shouldn't go back and look at prior proceedings. I'm asking why. It's just a hypothetical now. If everybody agrees that in the prior proceeding, the court met every requirement there is that was specific as a judge could be, why you're saying we, as a rule, we should not go back and look at what the court said?
What if that were to be the rule? What that would do would be to ignore the party's arguments made at the second hearing.
I think everything has to be on the record at the sentencing hearing that's given rise to the appeal. You want us to be confined to that?
I believe what would be appropriate is to be confined to, we appealed one ruling of the court, and that was the sentence imposed as part of the second supervised release violation hearing.
30 months.
Correct.
That's what you're appealing. But you say we should be confined to what's on the record in that proceeding. What if the judge said, well, for all the reasons I've said in the course of the handling of this case, I'm going to give him 30 months?
I think that would be better, and I think
you think that'd be better? Would it be enough?
Had he provided sufficient reasoning previously, yes.
Well, if he kind of adopted it all,
I think,
without reciting it, chapter and verse again. if he just that kind of adopted it generally, would that be enough?
Likely it would be enough. The burden is not onerous on the district court. And that is what is so important in this case is we're
So
not.
in the scenario that Judge King just asked you, you think that there'd been information in a prior hearing, there is a legal distinction on whether or not the judge says, for the reasons I stated before, I'm doing this. Isn't it clearly obvious that that's why he's doing it? If he says in the earlier hearing, I should put you in jail for these 5 reasons, but I'm not going to do it because I'm going to give you a chance. But if you don't live up to this chance, I'm putting you in jail. 3 months later, you're back, and there he goes. He knows he's been in front of him before.
That's correct.
And he says, I'm putting you in jail. Wow. But you say, if he just says, I'm putting you in jail, we can't look back. But if he says, I'm putting you in jail because I told you I was going to, makes a difference in what this court looks at?
This court doesn't require.
No, I'm just asking you a question.
I think it does make a difference because what we're asking the court to do is to put very limited statements on the record for why he did what he did.
You cited Carter. That's the only case. I think that's the only case. What does Carter say we ought to do about this?
Well, what Carter says is you have to put some reasons on the record why the sentence imposed was particularized to this defendant. And even if this court goes back and looks at the first hearing and the second hearing, the court didn't satisfy that requirement.
That's a different argument. That's a fair argument I think you could make. But you start out by saying that we should not, for some reason there's a rule that we should not or cannot go back and look up what the court did earlier. That's what you said.
Your Honor, I would start with that position. If you disagree with that position, we can go on and say even if you compare them in total, he still doesn't satisfy his burden. And one word that I would like to draw the court's attention to in the first hearing is the district court said, what I would do in this case normally. And I think the fact that he said very little in the first hearing, but by saying normally indicates to this court that he was not making a particularized assessment as to Mr. Fisher. And the court can consider that statement. Beyond that, he really doesn't say very much as to the specific sentence, why he's imposing it. And he certainly doesn't indicate, he says, I'll send you to jail for a long time.
Isn't it clear that he was saying to him, I would normally put you in jail, but I'm going to give you a chance? Isn't that what he did? Isn't that what he said? And isn't that clear at the first sentencing hearing? That's what this judge was doing. I'd normally put you in jail, but I'm going to work with you and give you a chance. You don't think that's obvious?
What this court has said in the past is...
I'm asking, do you think that was obvious at the first sentencing hearing?
I think it was obvious that if Mr. Fisher came back before him, he would give him a longer sentence. But there was no indication as to the amount of time. And so it's not simply, am I going to incarcerate you or release you, but how much time specifically...
How many hearings had the court conducted with this fellow?
Well, his sentencing hearing, the revocation hearing, and then the second revocation hearing.
So there's 3 altogether.
That would be correct.
So there'd be, when we talk about looking back, there'd be 2 prior records.
That's correct.
Right? Over what period of time?
Well, his original sentencing was in 2004, Your Honor.
Right.
So you'd be going back 6 years to look at that record.
And when was the second one?
The second one was in 2010, and then the first supervised release violation hearing was in 2010, and the second was in 2011.
So 7 years.
That's correct, in total. And so...
What at the revocation hearing, I think it was, at JA 33, the court says, because of this violation, the court will sentence Mr. Fisher to a period of incarceration for 6 months. And then supervisory release will continue. Mr. Fisher, like the prosecutor indicated, normally, I would be giving you a sentence of 5 years instead of 6 months. But I'm going to give you an opportunity to try some drug treatment. You can put him in jail for years, but instead, he's doing your client a tremendous favor. And he's making that clear, isn't he?
He does make clear at that sentence, but what this court and what the statute says is that you have to consider the arguments of parties and what happened after that hearing. And the court didn't do that. The government made arguments, and we made arguments as well.
Could the court have given him 5 years at that time?
He could have.
And so, and the court didn't. Clearly on the record, the court said, normally I would give you 5 years in prison for what you've done. This is a revocation hearing, isn't it?
That's correct.
But I'm going to try to work with you. It's not what I would normally do, but I'm going to try to work with you, individualized. I'm going to try to work with you in this case. Isn't that clear that he's just holding in abeyance that what he would normally do to give you a chance? What's not clear about that?
But Judge Shedd, what would we do if the judge said at his sentencing, if I see you on a revocation, I'm sending you to jail for the statutory maximum. He comes in with a revocation, which is simply failure to submit one monthly report, and the judge simply says, I find you guilty and I sentence you to 5 years.
If the judge made it clear enough why and why those things were important enough, I think that'd be perfectly fine.
I think that the statute, 3553C, and this court's holding in Carter says that that is insufficient.
If it's perfectly clear from looking at that the judge would do, and it might be harmless anyway, but if you could look back and it was sufficient and we could find that what the judge was going to do and it was individualized enough at the first sentencing, I think this court would affirm it, but that's for this court to decide. But what in this case, he should have done what? He should have said what at the second revocation hearing?
At the second revocation hearing, he should have said, I told you before I was going to sentence
but
you
I was teasing.
To a period of incarceration.
But I was teasing and I didn't really mean that.
No, I mean, he could have simply referenced his prior hearing and said, I considered.
Why does he have to reference it? It's on the record. You know it. The government knows it. The district judge knows it. And we know it. The public knows it. Well, who doesn't know that?
The requirement is not, what the law is not, we can look at the entire record to try to weed out what the judge is thinking. The requirement is that the judge state his reasons on the record.
If this is error, why isn't it harmless error?
It's not harmless. There are only 2 cases that I could find, and that certainly that the government cited, in which harmless error was found.
Did you articulate all your reasons for saying you ought to get 12 months or only 12 months?
Your Honor, I think there were certainly additional reasons we could have raised, but we did articulate several which had merit.
At the last hearing?
At the last hearing,
Okay.
That's correct.
And the judge didn't discuss those?
He did not discuss those. And when this court, this court has done is it said, let's compare this case to other cases to see whether there's harmless error.
How much of what you all were talking about related to events that had occurred over the previous 7 years?
We addressed some things that had occurred in the past, for example, his cooperation, but we also indicated that he had had other positive conduct on supervision and since being released from the first revocation sentence. So there had been new conduct, which we also referenced. What I think is important is that in this court, in the 2 cases in which it found harmless error, in both of those cases, those were guideline sentences, and the defendant actually received a low end of the guideline sentence. And in this case, which is substantially different, the defendant received a 60% higher sentence than the top of the guideline range.
Did you say you found a couple cases that said harmless error doctrine applies here or didn't apply here?
There were only the 2 cases, Your Honor, in which the court found that harmless error did apply was Hernandez-Frace, which is in this court, and also the case, the Boulware case. But in both of those cases, the defendant received a guideline sentence, which this court has noted is important, and it was at the bottom of the sentence. And so I think that makes it substantially different in this case than in other cases. The harmless error doctrine currently is very narrowly tailored. And if this court were to say, broaden it as the government asks you to do, you're asking the appellate court to step into the role of the district court. Basically, this court will be required to comb through the record to determine whether the judge stated anything on the record. This court will be required to consider the arguments of the parties to consider whether or not they are weak or strong.
But if in fact, let's just say this hypothetical, in fact, it was clear, if it's clear that the court's going to give that sentence, and there's an asserted violation of a procedure that he didn't spell it out as clearly for some particular reason, why wouldn't this court find that to be harmless? If the court says, I'm telling you, I've looked at this, based on what you did, this is the sentence you deserve, this is the sentence I would give you under the statute, my discretion, under the guidelines, under revocation rules, under any policy statements, this is the sentence you deserve. And then the claim is he didn't do particularized enough findings on one particular fact. Why wouldn't we apply harmless error?
If he had said that at the supervised release violation hearing, what you just said, that I think would be sufficient, but that's not what he said.
I know that, but then you think harmless error would apply in the appropriate circumstances in revocation.
This court has held in Boulware that harmless error can apply,
Okay.
and I don't believe this court is in a position to
Right,
reverse.
so you
Boulware.
don't argue with the fact that harmless error can be applied here. You just think factually it shouldn't be applied here.
I don't think I can argue that to this panel, given what the precedent in this circuit is.
So the answer to my question would be yes.
That'd be correct. Thank you, Your Honor.
Thank you. Mr. Young? It's a bad spot for that thing.
Good morning, Your Honors.
Yes.
May it please the court. My name is Roderick Young. I'm an assistant United States attorney in the Eastern District of Virginia and the prosecutor who prosecuted Mr. Fisher. Now, Your Honors, based on your holdings in United States versus Crudup and its progeny, this court reviews sentences imposed in revocations of supervised release to determine if the sentences are plainly unreasonable. If plainly unreasonable, the government has the burden to show that the error was somehow harmless. Like this court has done in all the cases analyzing this issue, I'll look at this in a step-by-step manner, first addressing whether the sentence was unreasonable. If you determine if it was unreasonable, whether it was plainly unreasonable, and if it was plainly unreasonable, was that error harmless? Now, the brief statement from Judge Spencer that is the nub of this argument, it was the following. Mr. Fisher, we have done all we can for you. Now, with that statement, looking at that statement in isolation, that statement probably is unreasonable. But if you look at that statement in the context of this case, my argument is that that statement is not unreasonable.
You think that statement is unreasonable, or you think it's unclear? What's unreasonable about saying we've done all we can do for you?
Not that it's unreasonable that we've done all we can for you, Judge, but it doesn't go through a step-by-step analysis.
You mean it's not sufficient?
Right. That's probably a
He
better.
didn't lay out why he was saying that.
Precisely.
That was the conclusion.
So it would be
Precisely.
procedurally unreasonable.
Precisely, Your Honor, yes.
And under her precedence, the district court needs to lay it out.
Precisely. But if you,
And you're saying, go ahead.
I'm sorry. But if you look at that statement in the context of Mr. Fisher's case, I don't.
In the context of the case, going back how far?
Going back to 2004, Your Honor, when he was a gang member.
You're saying we need to look at it. The Court of Appeals needs to look at it in the context of a 7-year record.
If you look at it in
Is
the.
all that in the record here, the 7 years? Everything that happened?
There are arguments in the record about what happened, Your Honor, yes.
Are all the 7 years of records in there?
The total 7-year record is not.
We don't even have it all.
Couldn't be. Not
So we
even.
don't even have it all. But we know there were 3 hearings.
Yes, yes. This is what you do know, Your Honor. You know that there were 3 hearings. You know what he was convicted of originally. You know the sentence that he was received originally. You know the fact that he got a 55% reduction for his cooperation. You know when he started supervised release. You know he violated his supervised release shortly after starting for the use of drugs. You know that the district court addressed that he used drugs, addressed that he had gotten a significant break, addressed that he probably should put him in jail for a longer time, but chose not to do that, chose to only give him 6 months, give him some more treatment, give him some more work.
Is this the 2004 sentence or is this the 2010?
The 2004 sentence is his original gang sentence where he
You're
received.
talking about that one right now.
Well, no, I'd actually moved on to the second one. So
To the 2010.
to the 2010.
But there's these two earlier proceedings that you're talking
Yes,
about
yes.
over that 7-year period.
Yes, yes. So that's in the record, Your Honor. We then come back for this next violation where the defendant gets out and he continues to use controlled substances, and he's brought back for using controlled substances and violating.
This is coming back in 2011?
This is coming back in
Now,
2011.
is that approximately a year? We're just talking about years. Is that?
Yes, that's
or is it
approximately a
months
year
rather than
later.
Pardon?
It's approximately a year later.
Okay.
All right.
So go back one time 1 year and go back another time 7 years.
Yes, sir.
That's what you say we can do to figure out whether this statement, we've done all we can do, is supportable.
I think to put that statement, this puts that statement in context.
You think we have to go back 7 years to put it in context?
I don't think you have.
Well, you need to be careful in the words you're choosing now.
I thought you were saying that.
Are you saying you have to go back, or do you say you can go back? Which is it?
I'm not saying you're legally required to go back, just to be precise.
No, are you required to go back to understand what the judge's statement means in context? Are you required to go back that far?
I don't think you're required to go back that far.
How can you figure it out from the 2010 hearing?
Yes, you can figure out from.
You sort of said that. 2010 didn't heat between the government, the defense, and the judge. They sort of summarized and talked about what had happened previously, didn't
Yes.
they? About the break he'd gotten.
Yes,
And
Your
you'd
Honor.
normally go to jail.
Yes, Your
So
Honor.
you have to go back beyond 2000, the hearing on supervised release, 2010?
Right. Yeah, just to be more precise, and
So
thank you
you
for
wouldn't go back
focusing
to
there.
2004?
Right.
You're
You don't-
abandoning that part then?
I'm abandoning that part from the standpoint, just to be precise, Your Honor. All that is contained in the 2010 hearing.
All right, so we just need to go, as far as you're concerned, we just need to go back to the 2010 hearing.
Yes, sir. Yes, sir. Yes, sir.
Just need to go back 1 year.
Right. So when you go back to the 2010 hearing and you
But the
examine.
2010 hearing encompasses the 2004 proceedings.
Yes.
So we're really going back 7 years.
Again, you don't have to go back 7
Well, we
years.
got to go back somewhere because
You've already said that what he says is not enough to pass muster. We have done all we can for you. That's not enough. The government concedes that. So what you're saying is this is harmless error because we can go back and look at the prior records or whatever and ascertain that what he did in the context of the whole record was reasonable.
Yes, Your Honor. I do think.
Is that about it?
That,
I mean, so you're arguing harmless error. You're up here today, the government's saying this is a harmless error case.
Well, I'm saying that I'm saying a couple of things. I think number one, I'm saying with respect to unreasonableness that the statement by itself, I see how it could give the court some problems. But if you encompass the 2010 hearing and what happened in 2011, I think that informs the court what that statement means that, Mr. Fisher, we've done all we can.
Now, you have to admit that this is your proposition. If we buy onto it here, is going to, for the future, potentially create a lot more work for the appellate courts and create less work for, looks to me like, district judges and people like you all in the district court proceeding. That you can just throw something out there and we can mine the record and see if it'll stand up. It's a lot easier for us if all of it's laid out. Don't you understand?
Certainly.
And we don't have to look for harmless error.
Certainly.
But when you come up here and say, I'm not relying on harmless error, it's all right there in that 2011 hearing. That would be a better situation
That would be the best way.
than what we have here.
That would be the best way, but that's not what I have for me.
You got to
Unfortunately.
play
So,
the hand you were dealt.
right, exactly. So,
Except that you were there.
Yeah, why didn't you say that to him instead of to us? Why didn't you say to him, if that's your position, why didn't you say that to the district judge instead of now standing in front of us and going, that's right, the district judge should have done that?
well, Your Honor,
Might that have been a little bit better approach if that's your position?
that would have been a better approach then to have done that. I did try to lay out on the record in my argument the various reasons why an above the guideline sentence was justified. The judge said what he said, and I did not get up and interrupt him.
It was an 18 months above the guideline?
Yes, Your Honor, the guidelines were 6 to 12 months, and he imposed a 30-month sentence. Yes, sir. Yes, sir.
Now, this district judge, if he looks at this transcript, is going to see that he was very clear what he did. This is what the district judge did, and it happens oftentimes. A defendant can and maybe should be sentenced to a greater sentence, but the district judge, for any number of reasons, decides to give the person a break. Oftentimes it doesn't happen, but in this case it happened. This district judge completely warned him, was explicit. I normally would give you more time. I'm giving you a break, but you understand, if it doesn't work, if the probation officer brings you back in here, I won't have any choice but to send you to jail and for a long time. So I'm giving you some opportunity. Now, all that being said, you're now saying that the district judge, because he didn't say all that again at the final revocation hearing, he didn't do it. He didn't handle it the way he should have handled it. That's what you're saying in front of this court.
Well, what I'm trying to say is this, Your Honor, and I think I'm agreeing with you in that if you just look at that statement by itself without anything else, so you don't look at
which statement?
The statement, Mr. Fisher, we've done all we can for you. If you look at that statement and don't look at anything else, I understand how that could not be sufficient. So that's what I'm trying to say. But just like you're saying, if you look at the 2010 hearing and put that sentence into context.
Which is the predicate for the statement, isn't it?
Yes, I agree. I agree with you. If you put that statement into context with the 2010 sentencing hearing, it is sufficient. Yes. So with respect to Judge King, I got away from your answering your question about harmlessness. But
are you abandoning harmlessness? And
no.
I'm just want to plant your feet and say it's not error.
We can do it this way, and we can do it this way, and you ought to uphold it. And that means we can do it this way next week too, and next month, and next year.
I think
we come up here with one statement, and we'll look back at the whole record, or you all can look back at the whole record and figure out whether it was right or not.
Right. Well, what I'm saying, Your Honor, is I think
that doesn't sound like what the Carter case says.
Right. It does not. But what I'm saying is,
but we'd have to change that then. We can't change that law. We have to adhere to the prior panels, prior precedent here.
You do have to adhere to your prior law, Your Honor. But what I'm saying is that even if for some reason you find that this was procedural error, I still think it's harmless for this reason. And the reason is that the district court, it's plain that the district court considered both arguments for two reasons. One, both the government and the defendant asked that the defendant, after being sentenced, be removed from supervised release, which the judge did. The second reason is that in considering the arguments of counsel, the judge didn't do everything the government wanted to do or didn't do everything the defense wanted to do, but kind of sliced the baby down the middle and sentenced the defendant to 30 months. So from that reason, for harmlessness, the government must prove that the error did not have a substantial injurious effect or influence the result. And it's harmless if the district court can say with fair assurance that the district court's explicit consideration of the defendant's argument would not have affected the sentence. Well, I think the judge considered both arguments because he didn't do everything that the government asked. He didn't do everything he intimated that.
The explicit consideration of the arguments. You just said there needs to be explicit consideration of the arguments. Where is that in the record?
It's not. He doesn't say it explicitly. That he doesn't go through Ms. Wilson's argument in checklist form and deal with the fact that the gentleman has had prior.
And Ms. Wilson is Ms. Haynes.
Yes. I'm sorry. Yes, Ms. Haynes. So he doesn't go through that in checklist form. But I think it is clear that he considered both of the arguments in crafting his 30-month sentence. So for that reason, Your Honors, I think it's harmless. So if there are no other questions for me, for the foregoing reasons, the government requests that this honorable court find that the 30-month sentence in this case was plainly reasonable.
Let me ask you this.
Yes.
If under harmless error review, you don't have to have any explicit findings, do you? Because if you had to have explicit findings, that wouldn't be harmless error, would it?
That's true. And what you also,
Wouldn't harmlessness come from the fact, if we could glean from the record, that the court was going to do that? That's where harmlessness comes in, doesn't it?
right, in Boulware, you all said explicit consideration of the defendant's argument, not explicitness in his statement. So yes, I agree with you, Judge Shedd.
I still go back. Isn't this what happened? He said normally. He says normally. What that means is, I'm ready to put you in jail for 5 years, but I'm going to give you a break. But if you don't take advantage of this break, you come back. You understand? I'm putting you in jail for a long time.
That's exactly what he said.
Either the court was serious about that, or the court was not serious about that.
I think the court was serious about that.
Well,
I think the court was serious about that, and I think that's what that statement means when he says, Mr. Fisher.
And the court did just what the court said it was going to do.
Yes. After considering.
Because the person could not abide by the rules and follow those restrictions.
Exactly. After considering Ms. Haynes' argument, he reduced it some, but he still gave him a significant amount of time. So I'll finish. However, if for some reason when you all deliberate, you conclude that the sentence is not plainly reasonable, the government will request that you find that the error was harmless. Thank you, Your Honors.
Thank you, Mr. Young. Ms. Haynes?
Thank you, Your Honor. What's most important when we look at harmlessness is that look at the sentence that this individual received. The guideline range was 6 to 12 months, and the sentence that he received was 30 months, a 60% higher than the highest guideline range. This court has only held harmlessness in 2 occasions, and in both of those cases, the individual received a low-end guideline range, and that makes this case remarkably different.
Let me ask
than
you,
the other.
is that a guideline range, or is that just that's not really a guideline range, is it, on revocation?
Well,
Isn't that just sort of by policy statement, otherwise what the range should be? Am I wrong about that?
In the revocation context, Your Honor, obviously it is slightly different.
I mean, I know courts call it that, but it's not really the guideline range pulled from the guideline chart, is it?
No, it's not. Revocations have their own guideline.
Is it a policy statement, or is there a chart?
There's a chart.
There is a chart.
There's a chart, Your Honor.
What's the percentage you gave us?
It's a 60% variance.
Where do you get 60% out of that? I would think it's 250. 12 months to 30 months.
I took the difference between 12 months minus the 30 months divided by 30 months.
If 12 months was the top of the range,
I'm an attorney.
And you went to 20,
I can't do math.
And you went to 18 months, you'd have 50%. And if you went to 24 months, you'd have
The point is, it's
100%.
substantially more.
If you had, would be 150%. Not too. We're both wrong.
Divided by pi.
It would be 100. If 30 months would be 150%.
The point is, when we look at Boulware and we look at the case that came out of West Virginia, the Thompson case, in those cases, the defendants received low-end guideline ranges. And Judge King pointed to the real problem with expanding the harmlessness doctrine is that it requires this court to step into the role of the district court, to go back and look at the entire record in the case, to consider the parties' arguments, to determine whether they have merit. And I don't think that that's an efficient use of judicial resources. When the district court says something on the record, it is.
How about this? How about this use of judicial resources? No appeal on revocation orders.
That would have to be taken to an en banc panel, Your Honor, and certainly could be done.
It's not just efficient use of judicial appellate resources, is it? You know, there was a day when sentences basically weren't appealed at all. I know that was before you practiced law.
That was a long time. They were like that. I practiced law when I was a prosecutor. You couldn't appeal sentences. They just, unless it was above the statutory maximum.
Well, and
that's why they came up with these guidelines.
In this case, certainly it was above the guideline range. And although the government says, look, you can look at all these arguments that the parties made and assume what the judge did, that's what Carter said you can't do.
Are you surprised that the district court put your client in jail at the final revocation hearing, was that a surprise to you?
Your Honor, I wasn't surprised, but for example, when the court gives their statements on the record, then the defendant hears it.
So you weren't surprised by that. Were you surprised by the length of the sentence?
Your Honor, I was. I think that.
You were surprised by that based on what? His saying you're going to get a long sentence?
I've seen, in this case with this district court, there have been times in which defendants in similar situations have received 12 months and a day. And so.
After the judge tells them, I'm going to give you a long sentence, you're surprised that this judge gives a long sentence? So what's surprising about any of that?
Well, what's not surprising is that he didn't provide his reasoning. And this court has.
But I'm just asking. He said, if you come, I'm going to give you, didn't he say I would normally give you 60 months? How much did your client get? Eventually?
6 months in that instance.
No, but I'm talking about eventually.
30 months.
30 months. He said, I'm going to give you 6. If you come back to me, I'm going to give you a long sentence. Is any of that a surprise that the judge gave you 30 months?
That's not what the statute requires, and it's not what Carter requires. So although I'm not surprised, certainly that doesn't mean that he's fulfilled his statutory obligations and the obligations that this court places upon him. And that's the real issue here. Thank you.
Thank you very much. We'll come down and speak with counsel and then take a short break.
Okay.
This honorable court will take a brief recess.
No,